Let me start out with 2 points. Number one, when we have a CLE in Denver, it's very easy for the lawyers from the Denver office to walk over to the venue. You have come a long distance, and thank you for doing that. It's very good to see you. The second thing is that you may remember Doug Richmond's talk from last year, and it was the war on error. And remember that one lawsuit where the law firm managed to goof up everything, including characterizing their client as Orville Rickenbacker. We'll have much the same thing today because if you look at whatever the errors of our lawyers have been in the past, it's just stuff where people don't think, people don't talk, people don't take the time it takes to do it right. And Anthony today is going to tell us a little bit about that. You may remember the last time that Anthony talked, it was about cybersecurity issues, and I think it was an OMG issue, or a moment for a lot of you. I think you'll get the same sort of reaction today. Anthony?
Okay. Well, not for promotional purposes, but for the sake of honest advertising, as of last Friday, I left Hinshaw and joined the firm of Clyde & Co. So actually the footnote at the bottom isn't right. Clyde & Co. is probably a firm you don't know well in this part of the country or in Denver, but it is actually a global law firm focused on insurance and insurance defense. And they have the largest legal malpractice defense practice globally outside the US, and they want to build it here, and likewise they want to build out in other parts of their universe the kind of counseling, risk management, professional responsibility work that I and some of my colleagues who move with me do here. So it's a different platform. Hinshaw is a great firm, but this is an exciting change. So next time we'll get the advertising right, because it won't be 5 days into the new regime. We're going to do 2 things. Before we get to mistakes, we're actually going to look at other people's mistakes. It's the first half of the program is called Dumb Things All Kinds of Lawyers Do. And some of it's just there for fun. How could anybody do that? But many of the slides I'm going to show you and the stories I'm going to tell you are actually they do have important lessons for everybody. The second half of the program, we're actually going to focus on mistakes. And we're actually I'm going to start with some of Doug Richmond's own slides to ram the point home about where they happen. But we're actually going to look, I think, probably a little bit differently than Doug does it. We're going to look at why they happen, and most importantly, we're going to talk about what you can do about it. And at all stages of this afternoon, I invite you to argue, debate, challenge, ask questions, but I know that by the time we get to my solutions, you're going to push back. And so we should have a good discussion in the second part about how you can run a practice today in ways that not avoid mistakes, but where they're properly managed and you avoid the implications and the outcomes of mistakes. So that's what we're going to do in the second half. Posted online, I believe, are all the materials that I sent Joe, and I'll refer to 1 or 2 of them, and you can go look at them later, but there's lots of good stuff in the materials supporting the slides. So let's start off with dumb things all kinds of lawyers do. Well, that was good. Oh, okay. So we're going to look at a lot of different things. This is some of them. Holding client money, you don't do very much of that, and my slides are going to show you why you don't do that and why it's a very good idea not to do it, and why it's a very risky idea to hold client money or any money in escrow. We're going to have a couple of cases involving conflicts. We're going to have some failures of supervision. We're going to have lots of stories about communicating without thinking. We're going to have some inadvertent production, some cyber disasters, dabbling, all kinds of things lawyers have done. All these stories are relatively recent, by the way. My colleague Janice Meyer and I collect these things, and usually we pick up about one new story a week, and we have to decide if it's better than the 50 or so you're going to look at. But it is quite remarkable the many ways in which lawyers find to get themselves into hot water. So this is just a fun one to start with. This is a New Jersey lawyer who ignored his clients and his practice because he preferred playing jazz. And he preferred playing jazz to the extent that eventually he was disbarred because he was doing it to the exclusion of his clients. So I suppose there's a lesson. And anybody musically inclined here? I suppose there's a lesson in this. But it is really about, if you're going to be a lawyer, then look after your clients. So we're going to talk a little bit, and we'll get it over with, the issues about holding money either for clients or in escrow or whatever. The basic rule is it's slightly different in every state, but it's 1.15 about handling client money. But the actual risks today are all very similar, and I've got three sets of slides. I'll go quickly through them because you don't do it very much, but the idea is this will show you why Joe has developed policies to try to prevent you from holding client money. Here's one. Susie represents John Quick. Susie asked John for payment instructions. She gets an email from jquok@gmail. She's suspicious. She calls the client, who says it wasn't his. She gets the correct information from him. She tells the defendant's lawyer of the payment instructions. But an hour later, the defendant's lawyer gets an email appearing from her, but wasn't. And he transfers the funds in accordance with the incorrect email. And of course, you guessed it, the email was phony, funds disappeared, they're in one of the stands or somewhere else. And the court, what's very interesting about this case is, the court says, we've got two law firms who we could blame for this. The firm that acted on the phony instructions, or the firm whose client gave, allowed there to be phony instructions. And the court says, Susie, the lawyer for the client who was supposed to receive the funds, should have known that her email had been compromised, that there was something wrong in the chain, and she should have alerted the lawyer who sent the money. So in this case, it wasn't the lawyer who misapplied the money, it was the other lawyer, because she didn't say, hey, there's a problem, we'd better have, I'll give you the solution in a minute, don't follow the email. And I'll make that point with the second one. Here's another one. Wage and hour case settled. Instructions from defendant's administrator Rust for wiring the funds, but the instructions weren't from Rust and the funds disappear. Rust says, where's the money? And he gets lots of silly replies, and of course the replies were bogus. Finally, he gets an email through to the defendants. No evidence anybody tried to call, and that's the punchline. If you can get through Joe's defenses and get permission to keep funds in the firm for any reason for a client, the last step has to be old-fashioned technology. Never just rely on the email. You must pick up the phone, speak to the person giving instructions, make sure you know that it's the right person, and get verbal confirmation as the last step before funds move. Now, interestingly, I hear this a lot, and I'm curious if it's the same for you. I hear from a lot of GCs and senior lawyers, it's very hard to get the X, Y, and Z Gen associates to use the phone. What do X, Y, and Z Gen lawyers like to do? Text. Email. Everybody has to understand personal communication, if not in person on the phone, is the only way to be sure you're sending money in the right direction. and it must be the last step. And there's another case, there are thousands of, the third one, another wire case, seller of a house, email hacked, wrong set of instructions, the firm follows the email's instructions, no call. This happens over and over again. So two things, that's why Joe doesn't want you to do it. If he lets you do it, no excuse. The last step is a phone call. You want to add anything to that? You want to talk about your policy? Okay. Sticky fingers. So I've seen this on more than one occasion. Cheetham and Howe had a partner, Snidely, who was a lateral. He came from another firm. He was hired to do trust and estate business. He has a lot of big clients, major estates. Managing partner keeps getting calls from one of the clients saying, "Where's my money?" Snyder's my trustee. He keeps promising the money, it never comes. Won't return my phone calls. What's going on? So finally, the lawyer and the client speak. The lawyer says, "I'm going to send the money." Next, when the managing partner hears again, he says to Snidely, "What's going on?" Snidely keeps saying everything's under control. Finally, the managing partner goes to the office of the partner and confronts him, and it all comes out. The partner has stolen $300,000 and has just been prevaricating with the client for years and years and years. And actually, this is in part a story about supervision. Once the alarm bell goes, the important thing about this story is the very first time the managing partner gets this call, the managing partner should have investigated. And there's a major case in Maine a few years ago where this happened, and the whole of the management committee was subject to discipline because they had notice of a partner defalcating. They covered it up for months for a variety of excuses that they had before they did the investigation. And the Supreme Court of Maine said that was a total failure of supervision. It's really important. Once you have a client questioning, you can't wait. You want to trust your fellow lawyers, but that's part of what the duty of supervision under Rule 5.1 is about. You have to go in and make sure that everything is getting done properly. Here's another one. This is pretty pathetic. It's Roll On Friday is everybody know what Above the Law is? Okay, well, Roll On Friday is the English equivalent of Above the Law. It's the Friday gossip sheet for the London profession. This lawyer paid out £1.5 million on a bogus lottery scheme, only using client money. He was convinced he was going to make much more, put the money back, and make a profit. That is, I think, the epitome of a dumb lawyer. But this one's quite extraordinary. It couldn't happen in a firm like yours, but it's worth telling the story. The firm hires, as an employee, a felon with a known history of embezzlement. And what job do they give him? They give him the job of administering the firm trust account. Outcome, $5 million goes, the lawyers get disbarred. By the way, it's very important to understand, in a lot of jurisdictions, if funds are stolen from the client funds, if you're holding them, it isn't just the partner in charge of the matter who gets disciplined. It might be all of the partners, certainly anybody in management is subject to discipline. It is really important to understand the supervision really applies very closely to the handling of funds because the discipline authorities don't just look at the lawyer who was responsible for the matter. Oh, this is a good one. And this actually, you'd be surprised. It's not, it happens to many lawyers. You get a discipline complaint. It happens. Somebody once grieved me. I was representing an estate. My client was the estate. one of the beneficiaries said, "You're not paying me fast enough," and disciplined me. It got dismissed. What you don't do when you get a discipline complaint is A, ignore it, because you can be disciplined for failing to respond, and B, you don't do what this clever guy in Florida did. You don't say to the complainant, "If I give you $7,000, will you make the discipline go away?" So, there's a right way and a wrong way for everything. It's very upsetting when you get a discipline complaint. The vast majority of discipline complaints are dismissed without any action. You have to respond appropriately. Same with a malpractice claim. Now, this is really serious, because depending on the wording of the policies, if you know that a client is very dissatisfied, you know that a client has threatened a claim, it is critical that you tell Joe, because Joe has the job of notifying the insurer. And the failure to notify after you've got notice of a claim can void your coverage. So not telling Joe is just as bad as paying $7,000 to the complainant to go away. You have to, this one got suspended as well as presumably suffering a coverage problem. Joe and I were talking about lateral moves just before we started. And here was a lawyer who moved from a firm, and the old firm wouldn't send the client files, even though the clients had said send the client files. So what did he do? He resorted to self-help. When I first was a lawyer, as a young barrister in England, the man I was apprenticed to said the best remedy in law is self-help. Well, he didn't mean committing a felony. You don't go and burglarize the old office to get your files back. Maybe it's because of the weather in Florida, I don't know, but that was where that happened. Now, this is important. This is an English story, but it's critical because it's true in every discipline. Rule 8.4 is the rule that says a lawyer shall not engage in conduct involving dishonesty, fraud, misrepresentation, or deceit. And what is critical to understand is that is not limited to that conduct in the context of law practice. This is a case of a fare beater. My wife was on the discipline committee in Manhattan, and she had a really wretched case once. A lawyer was so short of funds that he couldn't afford to pay the annual registration on his automobile. So he went to his wife's automobile, he took the sticker off her car, he photocopied it, and he put it on his car. And he suffered public discipline. I don't remember if he was suspended, but he suffered public discipline. Any act of dishonesty is going to get you in trouble with the bar authorities, even if it has nothing to do with law practice. So it's important to understand the scope of the reach of the discipline authorities. Here's another one. I don't know how he got his client's credit card, but he was using his client credit card to buy himself meals. The total that he wrote on the credit card was $2,000. Now, I've seen cases like this. Usually what happens is the lawyer goes on a very expensive trip and charges it to a client or charges it to the firm when it has nothing to do with firm business. It's dishonesty. It gets you disbarred. It gets you into serious trouble. It does happen. It usually happens when a lawyer is disgruntled, feels that she or he has been dealt with unfairly, and this is their way to get back at the firm or the client. And what's pathetic is very often it's for small sums of money. I had a partner, a friend of mine, who used to be the deputy corporate counsel of New York City. And he was in charge of all the litigation that the city was involved in. And he said every year there were one or two lawyers who would take bribes from the plaintiff's bar. And he said what was pathetic was they were always for $5,000 or $10,000. His point was everybody has their price. You can argue about that, but he used to say, everybody has their price. My price would be enough to buy me an island somewhere in the Pacific with no extradition treaty. I mean, that's the point. What's really sad about these cases is it's not worth it. The risk-reward of doing these stupid things just is totally out of balance. Here's one who got annoyed with a judge. Anybody here ever been annoyed at a judge? If you get annoyed at a judge, don't threaten the judge that you're going to pursue a citizen's arrest. It's not going to do well when it gets in front of the discipline committee. Now this one, again, another London one, but I've seen these in this country too. It just happens to be a recent one. What happens is, and this we're going to come to a bit more, this relates to stuff we will talk to in the second half of the program. So here's a young associate who's given control, the management of a case. And he ignores it. He doesn't listen to what the client was. He doesn't do the procedural steps. He doesn't tell the client what's happening. He doesn't file the defenses. And he sends, to defend himself, all kinds of untrue letters to the client about what he has done when he hasn't done them. When the firm finally caught on and twigged to what was going on, of course, there's a malpractice case and the associate is disciplined. But so is the management of the firm. So are the partners who are supposed to be responsible. Again, it's another case about the 5.1 duty to supervise. Every firm has it, every lawyer has it, everybody in management has it, every supervising lawyer has it. You cannot just let people act on their own. It creates this risk. And we'll talk about how to do that management better in the second part of the program. Now, this one happens, and I expect Joe sees this. I've got this great case, but there's a conflict, but we've almost finished the work for the other client. How many times have you heard that this month, okay? Can we get rid of this client? We're almost done. The partner who's doing that says he's just about finished, so we can take this magnificent, biggest case we've ever had. Well, here's one who did it wrong. He'd been representing Allstate, representing their insurers for years. He gets a big new plaintiff's case where Allstate's going to be the defendant. He takes on the new case on October 11th, and he fires the existing client on October 12th. No, he had a conflict on October 11th. He dumped the client on October 12th. That's called a hot potato. You cannot make a current client a former client at your own whim in order to get new business. I'm going to give you a longer story involving a major firm like yours. I don't think I have a slide. Let me just see what the next one is. No, actually, that's the next case. This one that I put up on the screen, the Shepherd-Mullin case, actually is a series of errors. It's hard to say that it's a dumb lawyer case, except I'll tell you what I think happened. So what happened in Shepherd-Mullin was the firm was representing a municipality. It was doing very minor bits of work, and the work was tailing off. They'd done 40 hours of work in the previous year. But it was still a current client. No one doubted that it was a current client. They had a waiver from long ago when they'd started the representation that they could be adverse in unrelated matters. Along comes a huge corporation which is being sued, JM Manufacturing. Remember asbestos? Johns Manville is what it used to be called. JM is being sued by 200 municipalities. One of them is the municipality that they were representing. And this piece I don't know, I'm guessing. But I think what happened was the partner who wanted to take on the JM representation to defend against these huge environmental claims called Joe's opposite number about 5:30 on a Friday and says, can we take this? I've spoken to the partner of the one of the 200 who we represent. The work's almost finished and we've got a waiver. And I think he said, well, if we've got a waiver, take it. Anyway, they did take it. And the minute they took it, the municipality said, oi, we want to disqualify you. So then they make the second mistake. When the municipality surfaces and says, we want to disqualify you, and we don't agree that the waiver covers, they say, well, will you give us a waiver if we give you all your fees back? Client says no. So then they say, this is all recorded, it's all in the evidence. Then they go back to the client and say, well, will you give us the waiver if we give you double what you paid us in fees? I'm telling you, lawyers and law firms do really silly things. The client said no. So eventually, after lots and lots of work on the case for JM, the firm is disqualified. And now, mistake number 3, and this is one that I'm sure you fight regularly. The partner who's doing the work for JM says they owe us $1 million. Can we please sue them for fees? Because we did perfectly good work until we were disqualified. Now, I have been told that the reason they sued for fees was tactical because they believed they were going to be sued for malpractice. I don't like that story. It may be true, it may not be true, but it doesn't taste right, and you'll see what happens. So they sue JM for $1 million. And there's an arbitration clause in their engagement with JM. And it goes to arbitration, and JM says, wait a minute, not only should we not have to pay you, but you should disgorge the $2.6 million we'd pay you on other matters, because you had a current conflict. When you took on this new matter, you breached your fiduciary duty. That means you should pay us everything back. So they go through the arbitration, and they win. They got their fees, no award of disgorgement, very happy. Now, JM goes to the court in California and says, you've got to set aside the arbitration on the grounds that the entire engagement letter, including the arbitration clause, was void because of the breach of fiduciary duty. Now, it's a very strange theory. But the court said, yes, void, and the arbitration agreement was under California law, not federal law. We believe the whole contract, including the California arbitration, is invalid, and we order that you disgorge all your fees. Goes up to the appellate court, upholds the trial court, goes up to the Supreme Court of California, who says the following. Number one, the waiver that you sought to rely on, and this is part of why this is an important lesson, the waiver you sought to rely on didn't help you, because they had waivers from both. They had a waiver from JM and a waiver from the municipality, and they were relying on the waiver from JM as to why they should collect their fees and had not breached their duty. And the court says the advance waiver from JM is invalid because you had a current conflict when you signed on JM. Now, they didn't uphold the automatic disgorgement. They said, go back to trial, which they're now doing, as to what should be the outcome of how much money you should pay back. So they will have been in 4 different tribunals before this is over. But that's the 4th lesson. First lesson is look at the waiver. And actually, the second lesson is even when you've got a waiver, if you want to rely on it, call the client. If I had to point to one mistake that everything else happened in the Shepard-Mullins story, the general counsel should have said, okay, I'm glad you've got a waiver. Come back after you've called the municipality to see if they will let you out. Because none of the rest of it would have happened. So the fact that you get advance waivers, it's a useful tool. All of you like advance waivers. It's a useful tool, but it is not something that always works. You should not rely on it other than as a lever to talk to the client. Everything else that went wrong in this comedy of errors or perfect storm, whatever you like to call it, could have been avoided. Now, this is a strange case. I included this case in the materials as well, the Skybell case. Almost every state has Rule 1.18. And that's the rule which says, if a lawyer interviews a prospective client and it doesn't turn into an engagement, the firm can represent somebody adverse in the same matter if the prospective client never became the client, if certain conditions are met. 1, in dealing with a prospective client, the lawyer got the minimum amount of information necessary to decide whether the firm wanted it and whether the client wanted to engage them. Secondly, it's in the meeting with the prospective client is in your conflict database, so as soon as the adverse party shows up, you start a screen right there. And if you put in a screen and only one lawyer or a couple of lawyers have met the prospect and don't have buckets of documents about the prospective claim, you will be unable to represent the adverse party to your original prospect. In this case, what the court said, well, wait a minute. You didn't just have one meeting. You got them to send you a whole bunch of documents. You kept the documents. You still had the documents when the other client comes along. And there's no way we can deem the screen adequate given that you still had all the information in your records. So 1.18 did not apply, even though it could have if they'd handled it right. But if you have meetings with prospects, it's really important to try and get as little information as possible. Some firms actually send letters. I don't know if you do when you're asked to bid on work. Some firms actually have form letters saying, thank you for inviting us to come and meet you about the possibility of representing you. Please don't give us any confidential information. Just share with us public information, because until you engage us, we are free agents and we can represent other people. And there are cases, I think there's even a Colorado case from a few years ago, which says that when companies go to all the lawyers in town to try to disqualify everybody, the courts recognize that kind of tactical behavior and won't disqualify. But 1.18 gives you a very clear mechanism for avoiding the conflict, providing you said, don't tell us confidential information, don't take in buckets of information, don't take all the documents, don't spend a month reviewing them, and then say, now we can represent the other side. The court's never going to accept your screen is adequate. Now, this is an extraordinary story. It was all over the New York Times. I don't know if it made it further west or south. But this is from this spring. There was a woman who was wandering around New York claiming to have this huge business deal and was in the process of getting the whole thing financed. And she took in 3 firms in a row, Gibson Dunn, Perkins Coie, and an East Coast firm, Lowenstein Sandler, totaling over $250,000 in fees. And the reason I tell this story is twofold. One, it's pretty bad publicity to be shown as an idiot, collectively. Why do you take on clients who don't have the money? And to say, I'll have the money tomorrow, or next week, or next month, is not the same as, yes, I've got the money now. It's not the same. And good client intake involves investigating people for their suitability. Now, there were lots of clues with this woman. First of all, here's an individual no one's ever heard of before coming in with this allegedly super colossal business deal. That's peculiar. Secondly, she's saying, I'm going to close on the financing soon. Now, why do lawyers take on work like that? Seriously, why do lawyers do it? Why do lawyers say, yes, I'll take you? Sorry? Because they need the work, and they think, they're credulous. They think, she presents well. What was that wonderful movie a few years ago? Tom Hanks was one of them, about a con artist who did all kinds of things, not just pretend to be a doctor, pilot, lawyer. Catch Me If You Can. The lesson of Catch Me If You Can, and the lesson of all these stories is, these people, con artists, are credible. They are good actors. They tell a great story. You can't rely on the story. You have to have an intake system that's robust enough to say, wait a minute, show me the money. Not tomorrow, let's make sure this is a suitable client that can, in fact, represent us. And of course, the second part of the story is, it's one thing to be the first in line. But what's the story of the second and third firm when she comes along and says, well, I wanted to hire Gibson Dunn, but I had a falling out with them, so now will you take it? That is a huge red flag. And neither the second or the third firm. Lowenstein's defense, when they were asked how they did it, well, we only lost $25,000. They still get in the paper. They still get in the paper. Client intake management is not just about checking for conflicts. It's about checking for suitability. Is this client a worthy client? Can they afford our fees? Are they asking us to do work within our areas of competence? Lots of things you have to look at. And there are no shortcuts. And if you take a shortcut, you get into the newspaper or the media and so on. Now, this is not an uncommon set of problems, different problem. Individual sues employer for discrimination, but is still working there. He tells her not to use the firm email for any purposes relating to a lawsuit, which is very good and important advice. You have to do that, because otherwise she's going to lose her privilege and confidentiality. But instead, she does something worse. She uses her position in the business to get hold of the employer's communications with its lawyers. And then she hands them to her lawyer. What are you supposed to do when this happens? Not read them. The rules vary in every state, but in this part of the country, the rules are very strict. You have to notify the other side, you have to stop reading if you've started, and you have to do what the other side tell you. Now, in other parts of the country, if you're in a litigation, in New York, it's much more complicated because the rule there only is you have to tell the other side. The law is very unclear as whether you can read and use. But you'd better know the rule in your jurisdiction before you start reading. And if you don't, here's your guy, because he knows them off by heart. Are they the same in all the states where you have offices, or they differ? Sorry? They're very close, okay. The most strict are in California, but I'm gathering from that Colorado is moving westward in that sense. Okay. Don't read them. And I've seen that this is by no means a unique story, and it keeps happening. And I've seen very adverse consequences for the lawyer. One lawyer, there was a case a few years ago, a lawyer had this happen. His story was interesting. The way that his client got hold of the document was it was during a deposition, and he and the client and the other lawyer and the other lawyer's client went out for a break, except his client stayed in the room and went on a fishing expedition in the other lawyer's briefcase and found the smoking gun document, went to the photocopy machine, photocopied it, put the original back in the other lawyer's briefcase, and afterwards brings it to his lawyer and says, "Here, look what I got." And the lawyer used it. Well, the court in that case did two things. One, it non-suited the client for the client's outright dishonesty. It says, we will not let our courts be used, even if it should have been produced in discovery. We will not let our courts be used by people who engage in dishonesty to advance their cause. And they then disbarred the lawyer for using it, for relying on the client's dishonesty. And there's a case in England where, in addition to those results, the firm was held liable in damages for the theft of the documents. So all kinds of adverse consequences. If you get something you shouldn't have or your client shouldn't have, stop immediately, lock it up, and then tell Joe. Don't do anything until Joe tells you what to do next. You must have seen some of these. Yeah, I mean, they do keep happening. And the lesson is critical. Literally, freeze in place and get help before anything else. Here's another one, similar situation, emails, same thing, keeps happening. Okay, there are a lot of things that we have to talk about lawyers doing wrong in connection with technology. Now, this is an interesting one because what happened here, how many people here blog or go on to listservs of your special area and tell people about your expertise and your successes? Anybody ever do that? No one's going to admit it? I bet lots of you do in your spare. When you have a success, you want to trumpet it, and there's nothing wrong with that. Well, what this lawyer did was, when he got a good result, he did a posting in which he said all kinds of nasty things about the other side. First of all, rule one is you never post anything about a matter you've handled for a client without the client's consent, even if you win, because the client may not want it known that they were involved in the lawsuit, even if they won, and even if it's in the law reports. It's different from being in the law reports from being in the business section of your newspaper. Secondly, if you say bad things about other people, they get angry. And in this case, the other party sued for defamation. And your insurance probably doesn't cover you the defense costs of a defamation suit. So you have to defend it. Now, they won, but defamation suits are messy, lots of discovery, they take a long time, they waste your time, they waste the firm's money. You have to be careful about what you post. Do you have any rule about what people can put on social media about the work they do?
We have a policy.
And where's the policy? And I'm not going to ask when was the last time anybody in the room looked at it, but the point is, all of you, the point I want you to understand is, those policies are there for a reason, because this is a dumb thing a lawyer did, and it's not unique, but it gets you into trouble, and it gets the firm into trouble. And more obviously, you don't insult federal judges. This person for insulting a federal judge was suspended from federal court and, of course, got reciprocally disciplined in the state where he practiced, which happened to be New York. Again, you see, these are all new cases. This is September of this year. This stuff lawyers keep doing dumb things, and I'm just trying to show you some of the things that will get you into trouble that you thought were obvious. Here's another one. This is really horrifying. A real estate lawyer, obviously only a New York real estate lawyer would do this, told the tenant that she ought to commit suicide. That's pretty awful. And he was suspended, and I'm surprised he was only suspended. It's outrageous. But there's another case I gave you in the materials. Another lawyer is whispering while the opposing party is giving evidence loudly so that everybody can hear, lie, 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 so that everybody in the courtroom can hear. Judges don't like it. Courts don't like that kind of behavior, and insulting and harassing behavior will get you into trouble. Now, this one's interesting. It goes back to the point I made about the identity of your clients being confidential. Here's a lawyer who moved to a new firm, just like I did last Friday. And I was very mindful of this on Sunday when I sent out my notices to everybody, including Joe. He put 600 email addresses into the to line so that everybody could see who else were his clients. So he breached the rule about confidentiality 600 times with one email. And all he had to do was put all the names in the BCC column, and each client would have got one without the other names. And this is not part of today's discussion. As you said, Joe, we did some of it last year. But even since last year, there are now 38 states that have followed the ABA and now say that competence under Rule 1.1 includes technological competence. Well, this is technological incompetence, not understanding how the technology that you use works, not understanding the rule about protecting client confidentiality when you use technology. Such a simple thing. Such a simple thing. Oops, July of this year. I'm sure we did reply all last year. We do when we do technology, but it never hurts to repeat the reply all. This was last year, 2018. There's an announcement. There's a letter from the departing partners, saying thank you all for the time we've spent here. We've enjoyed the collegiality, et cetera, et cetera. And the senior partner, who was really furious that they left, we were talking about that before, instead of letting it drop, sent round a reply all email excoriating the people who left. And again, that goes into above the law. So now he and the firm just look like jerks. Now you may not care, he probably didn't care, but it's about reputation. And using technology and using reply all can get you reputational harm, even if it doesn't do the other things about revealing confidential information that we talked about last year. Now, this is a situation that I have seen myself. If you do blog, if you do report cases and talk to people, this is an innocuous question. How many of you belong to listservs in your practice specialties so you see what's going on among your peers around the country? Thank you for telling us. I'm sure several of you do. And this is not uncommon. I'll tell you my equivalent of this story. I mean, the LA Bar issued an opinion saying, when you do it, you have to be very careful not to reveal the client identity. But it isn't enough to redact the names. And my story was, I belong to an ethics geek blog. It's not called that, but that's what it is. And one day, in an idle moment, of which I fortunately don't have many, I was looking at the blog, and I noticed a posting by another lawyer, about 3 paragraphs long, about the predicament in which her client found itself. It was a law firm, and the tentative conclusion she'd reached about how to handle it. And then there were about 10 replies from other people in the listserv about how else she might think about it. Now, she was very careful. There were no names. The only problem is, I was the lawyer on the other side. There was no way that 3-paragraph description of the facts could have been anything other than the case that I was handling. So she has revealed all her confidences, what she's learned from her client, and now I know her strategy, which was lousy, and all the other bad suggestions that everybody else on the listserv made. But the point is, if you tell the story, someone's going to know who it is without the names. You have to be very careful what you post. Again, you're revealing client confidentiality. The identity of clients is confidential unless they've expressly told you it's okay. Here are some more similar ones. I'm not going to go on ad nauseum about this, but sanctions for taking pictures of exhibits in a courtroom in a case the lawyer wasn't even involved in. Frustration and anger against the other side. A Georgia attorney venting about a client. You just mustn't do it. I saw an article in the ABA Law Practice Management section by a lawyer I greatly respect in the ABA, who basically reminded the readers of Abe Lincoln's policy. Abe Lincoln was a huge letter writer. And often he would write letters to adversaries or people he was unhappy with in very strong language. But he had an overnight rule. When he'd finished the letter, he would put it down and not decide until the next day whether to send it. And more often than not, he wouldn't. When he died, they found this drawer full of letters that he had never sent. Now, we don't like to do that. I know one lawyer in the country who has done something that Outlook allows you to do. He's put a pause on the send. When he hits send, he's got 2 minutes to stop it. Anybody else do that? Why don't you do it? You do it. Very good. Excellent. Now I know 4 lawyers who do it. How long? What's your pause time? How long? 2 minutes. It's not as good as Abe Lincoln's policy, is it? But it is good. It does allow you to breathe out and say, gee, I wonder if I could have done that better or if I should have sent it at all. It's a very good policy. Now, why don't the rest of us have a pause button? Why do we instantly want to hit send? Client wants it now. The real question is, does it have to be this instant, or could it wait 2 minutes? Think about it. I'm not saying the Abe Lincoln rule, overnight we're not going to do, but in our world, hasty posting, hasty sending tweets, hasty sending emails can get you into a package of trouble. That's why I'm showing you these messages. It's something worth thinking about. Here's another one about public disparagement. This time, the lawyer didn't disparage the adversary. It was a big firm, Pillsbury, and he was involved in a transaction, and he went and posted he didn't post. He spoke to a reporter in the Washington Post and was published and quoted about a company, Performant Financial. The problem was he hadn't done a conflict check. before he said all those nasty things about Performant Financial. Had he done so, he would have found that the firm was representing Performant Financial in an unrelated matter. The firm ultimately got disqualified because everybody concluded that there was no way the firm was credible in representing them after that had happened. So if you want to say bad things about anybody, do a conflict check. It's not on these slides, but we might as well get it in because I bet it happens. Subpoenas. How many of you have clients that like receiving subpoenas from other lawyers in Sherman and Howard? Do they stand up and clap? What do they do, Joe, when they get a subpoena?
Raise hell.
Sorry? They raise hell. Sometimes they fire you. Before you send a subpoena, before the partners tell an associate, subpoena the documents from ABC Bank or XYZ Corporation, do a conflict check. And if there's a conflict, Joe or the partner whose client it is will give them a phone call and say, do you mind if we send you a subpoena? It's just for records. We won't cross-examine you. We won't depose you. If you mind, we'll get discovery counsel. Don't just willy-nilly serve subpoenas. Sooner or later, you'll find yourself talking to Joe about a very angry client.
And some clients are unhappy about open records requests, too.
That's my point. It may, whatever it is, they may just not want to do it. They may not want you to do it. They may not want you to do it. Clients have different views about what loyalty means. Worse. Because there's, well, maybe not worse, but it's bother for them, isn't it? It's a hassle. Well, it probably isn't adversarial. I don't know. Actually, it's an interesting question, garnishments. I would have, if I was you, I would. The problem is you can't really call them about a garnishment, can you? Because they might move the money, they might tell the client. You probably have no choice, as I think about it. But you probably want to call them up the minute you serve the garnishment. I'm really sorry, I had no choice. I couldn't alert the other side. You still want to make the phone call. I'm sorry for the bother this is going to cause you. I'm sure it happens all the time. This has nothing to do with our relationship with you. I would just make that call. But you're right, you can't do anything about that. You've got to just do it. I agree. Become emotionally involved with. And so he set up a Match.com profile. Oh no, it was somebody he was adverse to. I'm thinking of another one. Somebody he was adverse to, and it said she liked to hang out in pizza parlors, buffets, and at NASCAR. And he downloaded her picture and put it on the Match.com dating site. And he signed her up for Obesity Action Coalition and Pig International. These are very funny, but you're lawyers. We don't do things like that, and we get discipline if we do. This one's worse. This was a Brooklyn DA who thought that he was being, I think it was a woman. She thought she was being cheated on by her boyfriend, and she forged a judge's signature to intercept his cell phone so she could find out who he was calling. She was convicted of the crime, and she was disbarred. Now, I guess we're not all DAs, but the point is, abusing process gets you into trouble. Now, this one is a very interesting story, this McDermott Will case. I gave you a note about it in the material. Okay, so here's the story in McDermott Will, this case. What happened was there was a big family estate feud. Litigation, big litigation. The critical family head on one side of dispute, we'll call him Grandpa, gets an email from his side's lawyers, not McDermott, the other side, about the strategy they were going to pursue and attaching all kinds of documents that hitherto had been privileged. Grandpa forwards that email to everyone in the family on both sides of the case. Not the lawyer, the client. McDermott basically collectively licks its chops. Whoopee, he's waived privilege. He sent it. We had nothing to do with him sending it. We can use it. So off they go. In a way, it's an extension of the other issue of inadvertently disclosed. This was deliberately disclosed. So McDermott will read it and use it in the course of litigation. When the other side, Grandpa's lawyers, realize what's happened, they move to seal the record and to disqualify McDermott Will. McDermott says, wait a minute, there was a waiver of privilege. For that California court, for whatever reason, it's a very peculiar reasoning, I happen to think it's wrong, says it wasn't a waiver of privilege. I don't understand why it wasn't a waiver of privilege. He didn't realize what he was doing. That was enough for that court to say it wasn't a waiver of privilege, and they disqualified McDermott Will. Now, I don't get the disqualification, both because I think what they did was reasonable, and secondly, what good does it do? Because everybody now knows what's in that communication, and surely someone's going to tell the next lawyer in line what was there. But the lesson is the same as inadvertently disclosed stuff. When you get something from the other side that you shouldn't have, even if it's from the other side's client, same rule, go and talk to Joe before you use it. Really important. Don't just barrel ahead because you make what may be a perfectly reasonable legal judgment. There was a waiver, I can use it. Now, going back to reply all, it's the reply all situation where this happens most often. And the way it happens, I did it last year, but I'm going to go through it with you again. Your adversary sends an email to his client and copies you, or sends an email to you and copies his client. What's the next thing that happens? His client hits reply all and attaches that privileged information. You say, whoopee, it was a waiver of privilege. The other lawyer says, no, it was inadvertent, you shouldn't have opened it. It's very important. On both sides of the coin, you never copy your clients on emails to the other side. You don't give them the opportunity to do it themselves. And when the other side starts sending emails that CC its client, you have to send them a message. And it says, don't do that. If you do that and your client sends us anything, we will deem it to have been deliberately waived from this moment on. You will not be able to argue inadvertent waiver. Don't put them on the communications between us if you want to maintain privilege. And then if he does it again or she does it again, now you can go to court and say, they had their chance, I warned them, I get to use this. But it's really, again, it goes back to technological competence. You've got to explain the consequences to people, and you do it to the other side as well as to your own clients. You don't want to get in the middle of one of these. I need to hurry up because we've got other things to do. Oh, this is another, we've done a story like that already. All right, I'm going to go on a few of these. We'll get to the other material. Okay, again, this is still technological competence, but it's important. I think it's since I was last here. It's using the cloud. I'll summarize it quickly. Client puts material up in cloud storage. Client's law firm puts something on the cloud so the client can easily access it, not encrypted. They use Box, a completely unencrypted site. You can encrypt, but there was no encryption. The other side got wind of it, goes up, downloads everything from the cloud that was on the website. So now there's a fight in court. The magistrate judge says, that's a waiver of privilege. You, the law firm, waived the privilege. You should have known it was no different than if you left a file on a park bench. You literally made it available to the other side. The judge, when it went up to the district judge, said, I'm not going to disqualify. I'm not going to treat this as a waiver. It was a mistake, but I'm not going to treat it as a waiver. But the judge did impose sanctions, quite substantial money sanctions on the firm for making the mistake. There are consequences to not understanding what you're doing. If you're going to use the cloud, do it with client consent and make sure you're doing it in a cloud environment that is as secure as it can be. And we could spend an hour on what that means, but we don't have it, so we won't do that today. Going back to the point you made, lawyers take work because they don't have enough to do. Don't dabble. This is just one of the many stories. Somebody says to the lawyer, I've got this really easy IP project. I just need you to do a little bit of IP work for me. The lawyer says, well, I'm not really an IP lawyer. And the client says, oh, this is totally straightforward. So you do the work, and later on, all the IP that you verified turns out to be bogus, and you get sued because you didn't know what you were doing. It's another element of good intake. Intake should be making sure that litigators aren't doing wills, and trust and estate lawyers are not litigating tort cases. I mean, you should be managing that at intake. Don't reveal. You can't use the self-defense exception safely in all states to collect a fee, and when you do reveal client confidences, if your jurisdiction has the self-defense, you can reveal confidences. It has to be to the limited minimum extent necessary to defend yourself or collect a fee, and it doesn't mean you can tell the whole story. You all heard this one. I'm gonna trespass on your time to tell you a story that I didn't put in a slide because it's too long, but it's the same point. I'll come to the pillow talk in a minute. This is my favorite article about dumb lawyers. It's a little long, but you'll see why. So this is by a reporter in England, but it could happen anywhere. Sitting at a table, enjoying my tea and a sandwich, I was joined by a rather smartly dressed young hotshot professional. Out came the laptop, the notepad, the two mobiles, the headphones, and his folder of work. On the opposite side of the carriage, his colleague did the same. The branding on their folder intrigued me. So I did a surreptitious search on Google, which led me to the homepage of a boutique commercial property law firm. This could be an interesting journey, I thought. A quick look at the firm's website, and within seconds, I had the names of the two lawyers, because he could see their pictures. A few more clicks took me to the LinkedIn profiles and their Twitter accounts. Soon as the train left the station, one of the two started making phone calls. One of them was to the client he just met. Calls to the client's boss, who wasn't able to attend, and the investment bankers who were financing the £100 million deal. Calls to his team, dealing with various aspects of the presumably confidential contract, and a couple of calls to his dad to remember to put the cat out. As the lawyer made and received those calls for nearly 2 hours, I was able to map out a very clear picture of what he was working on, the details of the protagonists in this massive deal, which the lawyer and all about his lawyer and his family needed to close within the next few days so he could go on holiday. Now, with all that telephone talk, the lawyer and his colleague obviously got thirsty. So they went to the cafe car. And he was very careful, says the journalist. He took his mobile phone with him. But there in front of me remained open the laptop, unlocked, the nicely branded folder of printed emails, his bag, and his credit card bills. Sam, the lawyer, were hungry or thirsty. They were away 8 minutes. I timed it, says the journalist. For that minute, those 8 minutes, he says, I had full access to his laptop, open in front of me, unsecured, with the added bonus for those 8 minutes of access to a wide variety of printed emails and even his credit card details. Any enterprising person sitting in that carriage could have walked off with a laptop. Or imagine what a common or garden fraudster could have done with all that information. Had the person had a few extra skills, they could have hacked his passwords or installed ransomware. It doesn't take long to do, a few seconds, maybe a minute or two at most. With the luxury of 8 minutes, it would have been so easy to install something very nasty on that laptop. And surely paying a few bitcoins as ransom to get back access would have been a small price to pay to close the £100 million deal. Does that ring any bells about people on airports, on concourses while you wait for your delayed plane? Anybody watched lawyers in the seat next to you or across the aisle doing stuff that you know what they're working on? Just understand technology is a trap. But just speaking in public violates basic confidentiality rules. Here's a case of a lawyer who brought work home and left it out in the open, and a family member engaged in insider trading. And there was another case last year on the East Coast that was just the same. I skipped over one. This was a case, I won't say which, but in one of the states, this was an Ohio case, where a husband and wife were both lawyers in different firms. The wife got very busy, so she started sending over files by internet to the husband who didn't have enough to do without telling the client. So the husband did the work, sent it back to the wife, who then passed it off as her work. This violates attorney-client confidentiality and all kinds of other things too. They both got suspended for 6 months, and they both lost their jobs. So I end this with my favorite 2 slides. I go to Maine every summer, and I saw a sign in the yoga parlor that I thought was very funny. When you get to the edge of the cliff, jump. And the message of this segment of the program is, when you get to the edge of the cliff, think. And your 2-minute pauses are really a good idea. I encourage the rest of you. Now, that's the first part. I wasn't going to have a break, but if you want to have a 2-minute break, we have to stay a bit longer, but I'll go on. Let's go to the second part of the program. Can we flip to the first of the other side? I've got a very few slides that actually are Doug Richmond slides that I use with his permission. I want to begin this. This is a program this section is about mistakes. And the first thing I want to say is tell you a story. He's now retired, but I had a partner who was a very distinguished lawyer. You must have seen him, Ron Mallon. Ron wrote the West, I think it ended up being a 6-volume tome on legal malpractice. And Ron was a brilliant lawyer, no sense of humor at all, which is why this story must be true. He told the story of the day he went to do a program like this at a fancy Midtown, New York law firm. And he said at the end of the program, the senior partner came up to him and said, "That was a complete waste of time, Mr. Mallon," and rushed him towards the elevator. And the senior partner said, "All of the lawyers in this firm went to Harvard or Yale, well, maybe one or two went to Columbia, and they don't make mistakes." So Ron says he gets to the elevator, and much to the senior partner's annoyance, he holds the door and says to the senior partner, "May I ask you a question?" The guy doesn't want to be completely offensive and says, "I suppose so. What's your question?" "I've heard about all your lawyers. My only question is, are they human?" People make mistakes. It's okay to make mistakes. The issue is, how do we avoid, it's inevitable that all of us make mistakes. The issue is not are we going to make mistakes, but what can we do to limit the harm they cause? Now, to give you some context about mistakes, and I'm going to talk about the kinds of mistakes that happen in a little while, but I want to use the Aon slides that Doug Richmond lets me use. 11 years worth of data, all different kinds of practice areas. What's significant is that bottom line. What are the causes of loss? Now, this is very interesting because Aon used to say that 90% of claims were because of bad clients. They used to repeat that, and Doug Richmond used to repeat that year after year. Now, they've got a bit more focused. 54% of all malpractice claims are from mistakes. And what's important, I'm going to go very fast through these slides. Transactional, 50%. Bottom line, just look at the bottom line. 50%. Commercial litigation, 41%. Intellectual property, 82%. That's because of missed deadlines, huge problem in IP work. Real estate, 58%. Securities, 42%. Trust and estates, 57%. You get the picture? Everybody makes mistakes. It doesn't matter what your practice area is. And I'm going to spend some time. We're not quite ready for those. We'll do them in a minute. What I want to do is talk about several different things about mistakes. First of all, I want to talk about why lawyers make mistakes. Why do mistakes happen? How do they happen? Well, it goes precisely to Ron Mallon's question. Human beings make mistakes. But there are some added reasons why lawyers make mistakes. One, ours is a very stressful business. We're not only managing our own personal lives and the things that go along with that, on our shoulders are the problems of our clients. That's stressful. The time pressure, and I don't care if you're a transactional lawyer or a litigator, you're under time pressure. You're working horrible hours. You don't get enough sleep. Maybe not all the time, but that's what stress does. We get distracted. We're not computers. We're not AI. We have other things to think of. Gee, did I remember to call the doctor? Did I remember to make that appointment? Whatever. Critically, and we could do hours on a program about this, and it's a very sad but absolutely demonstrated fact. Lawyers suffer substance abuse at a truly shocking rate. There's an ABA study that was done a couple of years ago of a very, very large group of lawyers in conjunction with the Betty Ford Center in Michigan, I think. Something like 36% of all lawyers have an alcohol problem. Doesn't mean they're drunk all the time. Way more than twice the general population. Anybody want to guess which age group has the biggest problem? If you had to guess, what would you think?
Oldest.
What?
The oldest.
Under 30. Now, no one's explained why. I have a theory about why. They learn it in binge drinking in college and in law school. I'm not pointing my finger at anybody, but that's the group with the biggest problem. And that was just a study of alcohol. But in the profession, and stress is caused by improper work conditions, harassment, Me Too, and there are other kinds of substance abuse too. Lawyers, and lawyers gravitate to this stuff because of the stress. There's a causal relationship between the two. So lawyers make mistakes. They're going to make mistakes. We are going to make mistakes. Each one of us is going to make mistakes. Our objective in this program is to look at two things. What kinds of mistakes are the most common? And then, most importantly, what can we do, if not prevent them, then to manage them? And that means identify them early and mitigate and avoid harm. That's what we can do, because 54% of claims are from mistakes. So let's talk about some of the typical lawyer errors. Let's start with the transactional lawyers. Drafting errors. What's the single word most often omitted from transactional documents that causes a problem? Not. But there are lots of drafting errors. I have a story in one of the materials about a case in New Jersey a few years ago. A lawyer is contacted by a very senior executive in the business world who says, will you please, I'm about to change and go work for super colossal ABC Corp. Will you please negotiate my new employment contract as president and CEO of super colossal ABC Corp? And the firm normally doesn't represent individuals, but they think we'll take this case because once he gets in, we'll get the corporate work. So the lawyer takes on the engagement, and the client says, I've got 5 objectives. And he lists 1, 2, 3, 4, 5. And the 5th one was that my shares and my rights to more shares vest in 6 months. So that if they fire me on 6 months and 1 day, it's mine. 5 objectives. So the lawyer goes away and negotiates a contract and sends it to the client for the client's review. Client says, I don't have time to read this. Did you meet my 5 objectives? Lawyer just says to him, you've got to read it. Tell me if it's what you want. Client signs the contract, goes to work for super colossal ABC Corp, and is fired after 5 months. And now he claims from the company all his shares. Sorry, not 5 months, 7 months. 7 months. He lasts the 6 months. No, you can't have it. You weren't vesting until after a year. So now he sues the firm for malpractice. And the firm says, no, you can't have malpractice because we sent you the contract, you read it, you signed it. Is that malpractice? Sorry?
It's not good practice. It's not good practice.
It's not good practice. What would good practice have been? What should he have done? When the client says, I don't have time to read this, what should he have done? Well, either he should have put in 6 months or he should have sent a letter. saying, here are the 6 critical things the contract does. New Jersey appellate court said, no summary judgment, no dismissal, that goes to trial. What do you think the jury did? That's a drafting error. Not in the literal sense of missing not. You're not accomplishing the objectives you agreed to undertake from the client. Those things happen because we're in a hurry, we want to get the deal closed, the guy's pushing us. The litigation issue that is most frequently a problem is missed deadlines. And one of the cases I gave you, there are lots, every week there's a new case, but the one I use is one involving Sidley and Austin and a case it had for AT&T. And they tried the case and they lost, and there was a $50 million judgment against AT&T. And AT&T immediately instructed the firm, one of the major firms, I think it was Sidley, appeal. So big team working on the case, and they're waiting and they're waiting and they're waiting because everything's electronic filing in that court. They're waiting to get the order that the judgment's been entered so they can file their notice of appeal. It never comes. 6 months go by. The senior partner way at the top of the ladder says to somebody down the chain, go to the court and find out what's going on. So they send a paralegal down to court, and lo and behold, the order had been entered 5 months before. And they then go through their email box, and they find they had got a notice from the court, including a series of orders that were mislabeled. And their excuse when they went to the circuit court for an extension of their time to file was that it was the court's fault for not properly labeling the orders that it sent through the electronic filing system. You're right to shake your head. The court said, absolutely not. It's not administrative error. It's not, you can't blame the courts. Your claim is no different than if we were in the 19th century and you didn't open the envelope. The courts are totally unforgiving for missed deadlines. I could go on for hours about missed deadlines. Totally, totally, totally unforgiving. They just don't want it. They want to get rid of their caseloads as much as they can, and that's an easy way to do it. Missed deadlines, huge problem for litigators. Technology. We've seen some of the technology pitfalls in the first part of the segment. I didn't go through the e-discovery malpractice cases where you disclose stuff that's privileged that shouldn't have been. The inappropriate emails that we talked about last year, we did reply all. We saw one where the firm had correctly told the client, don't use your employer technology. That happens all the time. People don't give that warning. And lo and behold, the discovery is lost. Now I want to show those videos. Let's show those videos. And this is what I call, we're now into forced errors. I'm not a great baseball watcher, but I know what a forced error is. Okay, let's see this one. Okay, this is a picture of a lawyer being taken out in handcuffs from a New York City law firm that was Arnold & Porter and Kay Scholer. It was Kay Scholer. He had joined Kay Scholer 2 weeks earlier, and he brought with him, remember the story about Shkreli, the pharmaceutical guy who was jacking up prices? Well, he was Shkreli's lawyer, and of course Kay Scholer wanted him because of all the money they were going to earn from that business. The problem was Shkreli was convicted of fraud, as was the lawyer. That's a client intake forced error. The next one's even better. Some of you may have seen this on 60 Minutes about 2 years ago.
Okay, good. All right. So why don't you tell us what you're looking for, and then we can tell you whether, to what extent we can help you.
It's very good. So make it very short, and I would want to be very frank because otherwise I can't get you a proper advice. I'm working as advisor for a minister of mines in a West African country.
At the University of?
No, minister of mines.
Mines?
Mines. In a West African country.
West African country, yes.
Right. That's very kind. So, you might know how things are working. There are lots of companies, and more now also from China, looking for minerals. So, our countries are happy to rent out part of the land or mining rights, because countries need revenues. Now, because there is a competition, companies are happy to pay a, how should I name, facilitation fee, commission. And so my minister over the last years got together a substantial amount of money from those facilitation fees.
Where is that money now?
At the moment still in West Africa.
It is in West Africa.
Yeah.
Who is it owed to?
It's not owed. It's his.
It's his money.
It's your money.
No.
He's
it's the minister's
representing
money.
the minister.
It's the minister's money.
China
Right.
China and other places have paid the minister facilitation fees
Got
to help them get some of these mining, so that
Exactly.
they. Okay.
Now, so therefore I'm very frank. It's, I would say gray money. I think somebody told me, you name it, black money, whatever it is. So it's not the proceeds of child or human trafficking or arms deals, but it's this kind of money. Because we think the state is a safer place to keep the money. On top, his wife wants to get something nice. She is adamant to get a brownstone. So minister, to keep her happy, because he has some, let's say, other mistresses, he wants to buy a brownstone. Starting with a brownstone, and then himself, to become more flexible, he wants to have a nice plane. He has enough money now. So might be a Gulfstream jet, whatever. So, but starting with the brownstone. Now we have to bring the money into the US. How to go best about it?
The first problem you have is you can't bring the money into the U.S. because the United States has an anti-corruption act.
Mm-hmm.
So you have to move the money to a neutral site.
Right.
Cayman Islands, the Isle of Man, whatever.
What did you just see happen? What did those lawyers just do? To do what? To launder money. They just engaged in a conspiracy to launder money. Now, the group that did that was an English NGO, and they went to 13 New York law firms at the same time. And the guy who was pretending to be the minister's aide was filming it, as you can see. Of the 13 firms they went to in New York, only one, the only solo practitioner they went to, stopped the guy halfway through and said, "You're a crook," and threw him out. Of the other 12, one of them was the immediate past president of the ABA. We don't have in this country the kind of anti-money laundering statute that they have in the UK and in other parts of the common law world, and even in the Middle East. So lawyers are not subject to reporting requirements as they are in the rest of the world. But in many parts of the world, long before that guy got into the office, they would have done all kinds of inquiry as to who he was and what he wanted and where the funds were coming from. And certainly before they started giving advice. Tell me again why they were having that conversation? Because they needed the work. And that's what I mean by a forced error. That's the other part of Doug's story for the last 20 years, the bad clients that you let in the door. And that's just one nasty example of a group of firms being suckered. And a number of the firms, a number of the lawyers involved, not the past president of the ABA, a number of them were disciplined in New York for that conduct. I don't think any of them were prosecuted, I don't know. So we have lots and lots and lots of ways in which mistakes happen. So now I want to turn to what I think is the most important part of this discussion. Mistakes are going to happen. They're going to happen in all kinds of ways, and they're going to happen in all our practice areas, and they're probably going to happen to all of us. So the question is, what can we do as lawyers? And more importantly, what can we do as law firms to identify them sooner and to mitigate them more effectively? Now, I'm going to give you 3 different approaches. I'm going to give you the worst case, the best solution, and you're going to have all kinds of reasons why you can't do the best solution. So we'll end up with the middle ground. Worst case. And I know you're going to be thinking in your head, who fits this picture? Very capable lawyer, bills lots of money for the firm. But on any given day, the only people she or he communicates with are her assistant, the receptionist, the client, and the lawyer on the other side of the matter. Who's missing? Colleague. Anybody else in the firm? That's a silo practice or a solo practice in the firm. Very profitable lawyers, maybe the only person in the firm with that specialty. Very common. When that person makes a mistake, when are you going to hear about it? When the summons and complaint comes in. So that's the problem. If everybody makes mistakes, and we have people who are operating on their own, we have no chance of identifying it early and mitigating it until it's too late. So now let's go to the opposite pole. And you're not going to like the opposite pole for lots of reasons, but we're going to discuss it anyway. And I'm going to show you what the good things are about it, and then you can push back. The opposite pole is every practice in the firm operates on a team basis. And a team practice has the following elements. Number 1, everybody must be part of a team. Number 2, the team is vertically structured, so it has senior people, mid-level people, younger associates, maybe even paralegals, and each team is 8 to 10 people in size, and that's based on extensive sociology. Bigger than that, you get cliques. Smaller than that, you don't get the value of the team. 4th, the team must meet periodically, and the frequency will vary with the kind of practice. Transactional teams will have to meet much more often because the transactions happen in shorter times. Litigation teams can probably meet less frequency. The critical thing about the meetings is not that every case is reviewed at every meeting, but that every case is reviewed frequently enough that it's reviewed before there are critical events. When a case comes in, it must be given to a team, not an individual. The team leader assigns the work around the team so that somebody or 2 people are responsible for each matter within the team. The team meets regularly, and when it meets, there's a calendar of when each matter has to be reviewed, and when a matter's up for review, the people who are managing the matter report to the rest of the team what they've done on the matter since the last session. Now, I want to look at that system from 3 points of view. What benefits do clients get? What benefits do lawyers get? And what benefits does the firm get from everything in the firm being practiced by a team? Start with clients. What do you think? What benefits do clients get?
More ideas.
They're getting the benefit of the experience and the thinking of everybody in the team. So they're getting best practice. Not one lawyer's best practice, the team's best practice. Probably the best the firm could do for them. Always. Every client's always getting best practice. That's not the only benefit clients are getting. There are at least two more critical benefits, yes?
Continuity of knowledge.
Yes. And it's very important to talk about the continuity. It's not only the continuity, but it's the spread of knowledge. The team leader or the person doing their matter may be off somewhere else. If it's a litigation team, she may be on trial. If it's a transactional matter, she may be at a closing and the client wants to talk to somebody. There's somebody else in the firm who's familiar and can quickly get up to speed and be responsive. Worse yet, from the client's point of view, the lawyer might be on vacation. How many of you in this room took 2 consecutive weeks vacation this year? Good for you, good for you, excellent. Much higher ratio than most firms these days. Why do the rest of you not put up your hands?
Greg's here.
Sorry? I know, but that's not the reason. Why do the rest of you not take 2 weeks? Why? You can't go away that long because the clients think you're indispensable. Note how I said that. I don't mean to be rude, but that's the reality. If you're in a team, well, we come back to the law, but the point is the client's always got someone who they know they can talk to and will get an answer reasonably quickly. So that we've got the best practice, accessibility of help, and there's a third very important benefit clients get from this system. Well, I'll tell you, I'll give you a clue. It's Thursday. On Monday, you're going to be reporting to the group about 3 of your matters. And since you met 3 weeks ago, you've done a lot of work on 2 of them, but nothing on the 3rd. What are you going to do tomorrow? You're going to work on the 3rd. Taken as a whole, what does that do for clients? When does it get clients' outcome, this system? What do clients want from lawyers? They don't want services, they want results, they want outcomes. So what does this practice of regularly reviewing do for clients? When do they want the outcomes? Exactly. It's just, forgive me for the analogy, it's no different than being a retailer. You're pushing the product off the shelf, and in order to push the product off the shelf, you have to work for which you can bill. But you have now, if a client's getting best practices, accessibility of people familiar with their matter, and quick outcomes, what one word would you use to describe your client, the clients under this system? Happy. Now, happy clients have 3 characteristics, which are 1, they pay their bills, they don't fight. 2, they send you more work. 3, they refer you to other people. Now, let's look at this through a different lens. The lawyers in the firm. What benefit do lawyers get from working in teams? And there are a lot of them, so let's hear what you think. Everybody's being trained. We're all learning all the time. Let's call ourselves the senior lawyers, learn the new tricks. The junior lawyers on their way up learn from the expertise of the seniors. Everybody's learning. That's one benefit. Everybody's getting trained. Sorry? Collaboration. Now, I want to really delve into that because when I talk to firms, and there are firms, but they're not generally big firms. They're usually boutique specialty firms. When I talk to lawyers who live in this kind of environment, what they say is, I love the collaborative practice, and I love the fact that all the responsibility isn't on my shoulders. I love that we do everything as a team. Think about what I said, why we make mistakes because of stress. It reduces the stress because we share the burdens. That's what happens when you collaborate. So I'm expanding on what you said, but that's critical. The benefit of collaboration is reduction of individual stress. There are more benefits that individual lawyers get from working in this. I gave you a clue before.
You get peer review to identify mistakes before.
Well, that we're going to come to with the firm, but yes, you're getting review, but it's not a benefit for the individual, it's a benefit for the collective. What are the benefits for the individuals? You can take vacations. Because, yes, but only when you practice collaboratively. That's what I'm trying to show you. And if you so you get lawyers who learn all the time, who have less stress than their peers who are working pretty much on their own. And they have the ability to rely on each other so that when they need to go to the ball game or they need to take a vacation, they're not indispensable. Yes.
You begin thinking and working the way your clients do.
And
You work and think the way your clients do.
that's right. Exactly. Now, you're going to fight me back in a minute. I'm going to give you your chance. But let's talk about the benefits the firm gets. And the first one is the one you gave us. If something's going wrong, when are we going to learn about it? In one of the meetings. You did what? Or why didn't you do the other thing? In all probability, we will have time to fix it. We may not even have a duty to tell the client because we've caught it in time. So the first, it's not, I think, the most important, but it is the risk management benefit the firm gets. The firm gets much more than that. What other benefits does the firm get? Remember, we have all those happy clients. What kind of benefit does the firm get from a bunch of happy clients?
More money.
More profitable.
And better allocation of your own resources.
And, well, we forgot that, didn't we, in the benefits the lawyers get. If we're regularly meeting, we see that the work is fairly allocated among the people in the group, so nobody feels hard done by it. The work is being shared, but that's part of the same. It's true for the firm as a whole, and it's true within the team. So we have happy clients who pay us our bills, so they make us more profitable. We catch mistakes earlier. There's another critical benefit, and I know you know what it is, in relation to the lawyers. Sorry? Well, that's too vague. I want a very specific benefit about, you were asking me at the beginning, what are firms doing to keep lawyers in the firm? Lawyers stay longer. It's very expensive to replace lawyers. All the studies show it's way into 6 figures every time you have to replace a lawyer. So the longer people stay, the more value the firm collectively gets from them. So retention of lawyers is a big cost saving and a big plus, both sides of the coin. Okay, why don't you do it? Why don't we do it automatically?
Engagement letter I get from the client says we will pay for no more than one partner and one associate on this.
Outside counsel guidelines say you can't do it. But they don't. They only say they won't pay for it.
That's a second reason.
And but you see, they don't say you can't do it. They just say they won't pay for it. So what I say to you is, it's yet again a client intake issue. When you take a case on, in this context, you have to make a judgment every time. Can we get the client to pay for this? Because sometimes if you talk to the clients and you say, you get huge benefit from our way of doing business, they will change the terms. And if they're adamant, because they're insurance companies, you have a different choice. What's your choice? Either don't take the work or do it and take it as part of your overhead. Now, bear in mind, we're talking an hour or two a week that you're not billing for.
Well, it's more than that. If you have a team of 8, you can only bill for 2.
Every lawyer in the firm is part of a team. So every lawyer in the firm is part of a team and spending an hour or two a week. That's a lot of hours over the year. But if the clients are paying you your bills and they're happy and we're not getting sued, so our premiums are going down, wishful thinking, in the current market, it's a cost of doing business well. And that's the challenge. And that's the challenge firms have got out of the habit of facing. But I want to ask, because I see there are some other folk here who go back as far as I do. Any of you have ever practiced in a firm where you had a weekly meeting with your team? See, quite a lot of you. Any of you do it here? That's a shame. Usually when I ask that question, somebody's doing it. I bet there's a pocket somewhere in your firm of lawyers who are having a weekly meeting about their practices. That's the basis of this system. They're sharing, they're discussing, they're going over the work, they're analyzing what each other is doing, they're helping each other. It's not the whole ball of wax, but it's a piece of it. But it is how law used to be practiced. And it's those outside counsel guidelines, and it's the client saying, I won't pay for meetings, that have forced us into the mindset, I'm indispensable because I'm the only one they'll pay for. So what I'm saying is what you can do if you choose is weigh all those benefits versus the fact that you lose some billable time. And my recommendation to firms, if you're even thinking about doing it, pick a practice area. Try it for a year. Get a volunteer group that's willing to try this and see what benefits. If I'm right, you get the benefits. Try it. Now, it's very hard to do, especially, and by the way, technology means that the people don't all have to be in the same office. That's why we have video conferencing. If you're not going down that road and you don't want the silo practice problem, is there a middle ground? And the answer is there is a middle ground. And I'll tell you the last one of my stories to give you a context for the middle ground. So a few years ago, an insurance company calls me and says, we need you to go and see XYZ law firm in a western state. And they say it's a firm of about 40 lawyers, 4 or 5 or 6 partners. They've never had a claim, a malpractice claim. But every year for the past 5 years, they have reported a set of circumstances that scare the daylights out of us. They keep getting sued not by their clients, but by their adversaries for breach of abuse of process and all kinds of things that the adversaries say they're doing bad things to them. Malicious prosecution, breach of process, sanctions for what they did. And we're convinced that we're going to see a massive claim because they're obviously doing something wrong because we've never seen anything like this. Circumstance after circumstance. So will you go and do an audit? And you can tell them while you're there that if they don't do whatever you recommend, they're not getting renewal. I have no insurance. So I go to this rather distant location, not in a major metropolis, but a significant firm in its location. And usually it takes me a day to figure out what's going on in a law firm. I figured this out in 10 minutes, maybe half an hour. They had the exact antithesis of the team practice that I described to you. They didn't have collaboration. They had competition. Each partner was vying to get the reputation as the worst, meanest, most macho, ugliest, nastiest litigator in the county. That was their objective. They wanted to be known as the baddest of the bad. And they were fighting each other for that reputation. So I said, okay, you can keep doing that, and you'll have no malpractice cover. It's your choice. That's how you want to do your lives. And, I hope your houses are all in your significant other's names and that you stay married and don't get divorced, et cetera, et cetera. It's up to you. If you want insurance cover, here's what you're going to do going forward. Now, bear in mind, this was a litigation firm, and I guarantee if I ask you, do you have a second pair of eyes rules for opinion letters, the answer is yes. So just remember, you already do this, or a piece of this. I said to them, you're going to sit down and decide the 4 or 5 most significant steps in the kinds of litigation you do. Presumably, it's pleadings, it's motions, it's pretrial orders, whatever. You choose the most significant steps. And from this day forward, when you get to one of those significant steps in one of your matters, you must show your work product to one of the other partners who is not working on the matter before it goes out the door. That's going to be how you practice going forward. In other words, a second pair of eyes for every significant step. Now let's think about that. How does that change the behavior of each lawyer just by imposing the second pair of eyes? What does it do? You're nodding. What do you think it does? Yeah, because you don't want to show your partner's slovenly work. So every bit of work you show is going to be that much better than it would have been before. But more importantly, when you show a piece of work to another lawyer, what happens? Sorry? They revise it. Do they revise it for better or for worse? Well, but usually it's better. The answer is at least you're getting the product of 2 minds. You're getting 2 pairs of eyes on each bit of work product. So you're getting some of the benefit. But you're certainly going to catch the most egregious things. You can do that. You can do second pair of eyes. Each practice group can figure out whether there's 1 or 5 points at which, if you're doing an estate plan, it's before you send the client the will. But every practice area can have a second pair of eyes moment or set of moments. It's not as good as team practice, but it at least does the defensive thing. And it reduces the amount of unbillable time. So that's the middle option. Impose the opinion letter rule across practice, second pair of eyes, each significant step. And I don't mean when there's a partner and an associate. The associate isn't a second pair of eyes. Somebody off the case. Somebody not working the file. You haven't given me enough pushback.
I rarely let anyone out of the office without having everybody on the team review it.
Good.
But they're not, somebody on the case.
Right.
It's not going to
Somebody else, right.
who's not on the case, who
You're about 3/4 of the way there, because at least you've got multiple eyes. At least you've got multiple eyes. And for some firms, that may be enough, that we know that, assuming they're not all baby lawyers just out of law school.
You know what, even if they are, they review it and they comment, and
They may not, but they're not going to catch the stuff.
test that.
Yeah,
The team.
that's good.
And David, I think we do that pretty much across the
Yeah, I
litigation.
think we do.
In the Phoenix office,
Yeah.
almost everybody.
Could be the transactional area.
Sorry?
Could be the transactional area that's the problem.
Yes, and it's most likely because there's more people involved in litigation as a rule. It's more, the silo lawyers are usually transactional lawyers.
Greg, what do you think?
We do have, in the transactional practice group, we do have requirements that operating agreements, shareholder agreements.
Good.
Disclosure documents.
So you're doing it.
Party opinion,
All right, so you are doing it.
second review of another.
Good. Then you're doing it. That's terrific. That's good. But if I was in Joe's shoes and had the whip, do they give you a whip? No. If I were in Joe's shoes and I had the whip, I would see that that was happening in every practice group. That's exact. And you've got good examples. You've got litigators and transactional lawyers doing it. Every area, not by office, by practice.
Let me give you the hypothetical. Let's suppose you have a person, silo practice.
Yes.
Doesn't think that he or she will benefit from any.
And they'll never make a mistake.
Never make a mistake. So is there a sanction policy, or how do you bring those?
My view about silos is very simple, and I have a very, very, very simple rule. This is not used for religious purposes. I call it the Noah's Ark principle. You never have one lawyer working alone. You've got to have two. If you can't justify two because there isn't enough work for two, find a nice home for the one lawyer somewhere else. Because that's the silo, that's the one when the claim comes in, it'll be a humdinger, and you'll see it when the summons comes. At least let there be two. That's my rule. Well, you've earned your 2 hours of ethics credit, if nothing else. Thank you for coming.